Please be seated. We'll hear argument in case number 25-0008, in re CS and ZS.
Please the court. Mr. Bedford will present argument for the petitioner. Mr. Hampton will present argument for the ad litem. Petitioner has reserved 5 minutes for rebuttal. Mr. Bedford will open with the first 11 minutes and will present the rebuttal.
May it please the court. This case concerns extension orders under Texas Family Code 263-401 and whether or not termination was in the best interest of the children. The first issue I wish to address concerns whether or not the trial court rendered orally or in writing an extension prior to the original dismissal deadline.
Was that extension hearing heard by the associate judge?
It was heard by the associate judge. It's the child protection court judge of the big country.
Okay, so my question is, my understanding is that there was a record made under 201.09 that allows a record to be made, preserved by any means approved by the associate judge. And that was done here, right? So
there was a audio recording made.
Right.
Yes, that is correct.
So is that a problem?
It is a problem because first of all, 101.026 provides that to render means a trial judge's pronouncement on a matter, and may be done orally in the presence of a court reporter, it states, or it may be done in a written instrument such as a docket entry. Now, I think the importance of that in terms of the presence of a court reporter is that if you look at the reporter's record of those hearings, there are numerous gaps in the record, like in the 223-24 pretrial hearing, that's critical in this case. There are 5 instances where the record, where the audio cut out was unintelligible. Then at the January 26, 2024 pretrial, which is also critical in this case, there were 6 instances of an unidentified speaker and 3 instances where the recording was inaudible.
But what about this hearing that we're talking about?
This hearing, yes, that's what I'm saying, on the 223-24 hearing where the extension was purportedly granted, that was an audio device. It was not memorialized in the presence of a court reporter. And I think this court stated...
What Justice Lehrman is saying is this statute says it doesn't have to be. So because it was an associate judge, so what's your response to that?
I have not looked at that issue. I would have to do further briefing on that. I can submit a post-trial briefing on that particular issue.
And also, just because there are gaps in the record, I mean, typically in civil cases, we deal with that one of 2 ways. Either we presume that the missing material is favorable to whatever the trial court's order was, or if it's so much of it is missing that you can't tell what should have been done, you order a new trial. So in either case, we'd be back sort of before any of this expired. So I'm not sure that helps you.
Well, I mean, I think what this court stated in the Stubbs and Rogers opinions that the trial courts have an affirmative duty to ensure that a proper record is made of these hearings.
So we can send it back and let the trial court make the findings.
Yes, and this court also states in that opinion, if I may, that it is the responsibility of the trial judge to see that the court reporter performs his duty, not an audio device. This court stated in the Stubbs opinion, 645, it is the court reporter that has to perform this duty. And so I think that's pretty clear. And so, I think the error is on the face of the record. There's these gaps in here. We don't know what was said. We don't know what we don't know. And so I guess my argument would be that is a structural error or error on the face of the record.
And the remedy for a structural error is a new trial.
Yes, Your Honor. That would be a remedy.
Not a dismissal.
Well, I guess not, Your Honor. And so, I mean, assuming the court would agree to me that there was no valid oral rendition, the next question would be whether or not there was a valid written rendition. And I, again, would argue that the answer to that question is no. And that's because there was no order signed by the court until after the dismissal deadline. There was no docket entry made by the court, period. And their respondent notes that there was private notes made by the trial judge.
Yeah, there was a notation. Was that in the record that was available to the to the public?
That was not, it was, those were not
Where
made part of
was it?
the.
What was it? Explain to me what that was exactly.
Those were, so the court generally makes a chart when we have pretrial in Taylor County of all the cases that are set for pretrial that day. It's an Excel chart. And so that's what that was. It had all the cases set for pretrial that day. And the trial judge and the court administrator wrote EXT there, noting presumably that it is an extension. But that was not made part of the public record until after the deadline, and it was only made part of the public record in response to petitioner's motion to dismiss.
So that was never put in the court jacket?
Not before the dismissal deadline. It was not. And I think this court was pretty clear in Baker v. Bizzle that private writings or private communications cannot suffice for purposes of effective rendition. And so I guess my argument there is that there was no private writing either. I'm sorry, there was no writing showing a rendition of extension order. And I also think there was some evidence that there was no present intent by the court at that hearing. And this court states in Baker v. Bizzle that courts must expressly state or expressly have a present intent to render a full, final, and complete judgment, not intending to make a judgment in the future, not to provide guidelines. And the evidence, I think, that points towards that is that the trial judge directed the department's attorney to provide it with a extension order prior to the dismissal deadline. If the court had believed that it was granting a full, final, and complete order at that time, that would have been a necessary step. Additionally, there were no mandatory findings made at that time. And
Was an objection made to that?
My client or petitioner was not present at that hearing. And so there was no way she could.
And why wasn't she present?
She had a medical issue that prevented her from attending that hearing, and the judge was aware of that before the hearing. And if you look at the record of that hearing, of the 223 hearing, the court references that trial counsel for petitioner let her know before the hearing that she was not available because of medical complications.
Did she file a motion to continue, or did she?
She did not file a motion to continue, no, Your Honor.
So would that amount to some type of waiver?
I mean, I guess arguably it could. She was.
Didn't they get counsel on the phone or something like
She was,
that?
yes.
And she was in agreement to the extension?
There was nothing on the record indicating that she was in agreement to the extension. Trial counsel for the department was directed by the trial judge to step outside the courtroom and to call or text petitioner's trial counsel. She did that, and what was indicated on the record is that there was no indication that they discussed an extension. What they discussed was the setting of a trial date and her availability for setting of trial dates. Now, those were after this.
Isn't that the same thing?
I mean, admittedly, sure. I mean, she had notice of the fact that this case was set for, had a dismissal deadline on March 11th, 2024.
And didn't she go look at her calendar and try to figure out what a date would work for her in her schedule?
I don't know what she did, Your Honor. I know that she stated at the hearings on the motion to dismiss that she was under the influence of quite a few pain medications, and so from what she stated in that record of those hearings was that she was not aware that an extension was being considered. I think she looked at her calendar on her availability, is what I gather, and said, yes, I'm available these days. But I don't see anything in the record, and she stated that she was not aware that an extension was being discussed at that time.
It's still, it just seems to me she would have to know that if she was agreeing to a date that was after the deadline.
I mean, certainly she received notice early on in the case of what the dismissal deadline was. Whether or not she actually knew and was aware of that at the time of that hearing, she denies that. There's nothing on the record. These conversations took place off the record, and so we don't know what we don't know. I just know what was stated at the dismissal, at the hearings on the motion to dismissal on April 12th and April 19th. And she stated at that time that she was not aware that an extension was being discussed. But she did acknowledge that, yes, I had notice of the fact that the dismissal deadline was March 11th. And yes, I agreed to a trial that took place after the dismissal deadline. That is correct, Your Honor.
And she realized that before the end of February, right? So before the dismissal deadline, she learned that there was a new trial setting because of the
My
extension.
recollection...
And even in that period, she never made an objection.
My recollection is that she stated at the dismissal, the hearing on the motion dismissal, that she became aware of the trial date or looked at the court's docket on the 27th of February. And she later stated in the motion to dismiss that, yes, I was aware the dismissal deadline was coming up, and she acknowledged that she waited until after that dismissal deadline to file her motion to dismiss. She did. Now, the respondent characterizes that as setting a trap. But I guess I would disagree with that characterization. The department it's their case. They are aware of the deadlines. They are aware of what's required to properly extend these cases. And so they too, I believe, have an obligation as the entity that's removing these kids, as the entity that's, interfering with these families, to also be aware of these deadlines. All that was required is a timely submission of an extension order by the department, or simply a docket entry by the trial court. A lot of these issues can be resolved quite simply. I think there's a clear legislative purpose and legislative intent by the state to limit the duration of these cases, and also to limit the number of unnecessary extensions of these cases. And that's also reflected in 263-402, that doesn't allow extensions by agreement. And so I think, there seems to be a tendency to blame petitioner, but I think also the respondent bears some responsibility as well in terms of ensuring these cases are resolved timely and that they follow proper protocol and exercise due diligence in these cases as well.
Thank you, counsel. Any further questions? Mr. Hampton?
Chief Justice, Justices, may it please the court. I bring to you today the issue that is most important to the children, and that is whether or not it was in their best interest to terminate their parental rights. And their position is that it most emphatically was not in their best interest.
So let me ask you this. Say if we agree with you on that,
Okay.
this is certainly a closer case than a lot of them that we see. But nevertheless, we do have to defer to the lower courts. So given the testimony and the evidence that is there, that has to do with a gun, that has to do with cocaine use, that has to do with marijuana being found in the bloodstream of the children, how do we get around deferring to that lower court?
The court has to defer to the trial court unless the trial court's determination was unreasonable. And in this matter, I believe that it was. You have possibly 8 of the 9 Hawley factors favoring the children's position that their mother's termination of parental rights was not correct. Oftentimes in these cases, you have arguments of the parent's inappropriate or appropriate, one or the other. So we should either terminate, not terminate because of the parent, or the state has an alternative proper thing to do, which is terminate. In this matter, you have a family that's involved, 2 sets of grandparents that are involved, that create an alternative disposition for these children that does not necessitate termination of the parent's rights, but instead preserves the family, preserves the desires of the children, provides appropriate emotional and safety mechanisms for these children.
I think the plan, though, from the department is to keep the children with the maternal grandmother or the maternal grandfather, so the family would still be intact in that sense, right?
The extended family would still be intact. The family unit as a whole would not. Additionally, with termination of parental rights, that is at the discretion of the court and the department, ultimately, whether or not those children remain with those family members. they are at the whim of other people. Whereas an alternative resolution, which is pled for by the department in their pleadings, was to grant conservatorship to the grandparents, which would then preserve the family unit, would preserve the desires of the children, would preserve an alternate desire of the mother, and would frankly...
But that's what I was saying.
Yes, ma'am.
That's what I meant by the question.
But that's not what they did. What they did was they terminated, which leaves the children at a much more fragile position in relation to not only their mother, which now is non-existent, but also to their grandparents, because the grandparents could have them taken from them at any point by a court or by the department.
So is that how the Hawley factors work? Do you sort of you got to look at two sides. So you've got preserving the, not terminating the mother's relationship, parental relationship, but the conservatorship is actually with the grandparents and she doesn't have conservatorship. Is that on one side versus termination, or is it full custody and conservatorship to mother on one side and termination on the other when you're figuring out which of those is in the best interest?
I think you have three different possible resolutions, and best interest relates to all three. And in this case, two of those possible resolutions favor or in the best interest of the children. There was the mother's argument that the children should come back to her. But if you look through the Hawley factors, they're relating to not just parents, but they're relating to people who have the children or who desire to have the children. So that has to be taken into consideration as well.
So termination has to be in the best interest of the children versus a situation where the mother is still their mother, but they're with the grandparents.
Because safety is guaranteed. Emotional safety is guaranteed. And most importantly, the desire of the children is guaranteed. I believe that there's a reason that the very first Hawley factor is the desires of the children. It's the oldest case law that Hawley cites. I believe it's from 1956. And there's a reason for that. At the end of the day, the mother, or at the end of the day, the prosecutor goes home. At the end of the day, the defense attorneys go home. At the end of the day, the judge goes home. At the end of the day, the appellate courts go home. At the end of the day, I go home. Even the mother at the end of the day goes home. But the children are required to live with the decisions that each and every one of us have been making about them and will be making about them for the rest of their childhood, if not the rest of their adulthood. So it is very important that the desires of the children, if an alternative, safe environment can be found and created and structured under the law and under the orders of the court, that their desires be frankly paramount, especially if safety is guaranteed through an alternative arrangement.
Any further questions? Thank you, Mr. Hampton. We'll hear from the respondent.
Thank you, Your Honor. May it please the court, Mr. Lindsay and Mr. Stevens will present argument for the respondent. Mr. Lindsay will open with the first 10 minutes.
Your Honors, I'd like to discuss today some of the facts that may not have just jumped out of the briefs or the record, and discuss extension and findings under y'all's case of in the interest of JS. But before, I'd like to begin by saying the reason that we're here is because these civil prosecutors in our office did exactly what the legislature and what this court wants to see: to pursue parental reunification whenever possible, keep the child with family when reunification with the parents isn't possible, be good stewards of public resources by keeping children out of the foster care system whenever that's possible, and just basically keeping government intrusion out of families' lives when necessary by ending these cases and returning them to either the parents or the family. And if that hadn't been the case, then we wouldn't have seen all of these asking for more time and pushing right up to the deadline, because the petitioner, Ms. Watkins, was doing well up until we found out that she was actually still using cocaine and deceiving the court, et cetera. Among the facts, we don't talk about it much in either of our briefs, but in the first pretrial or permanency hearing in December of 2023, the court actually asks Ms. McGee, our civil head chief, why are we pursuing reunification in this case? And she says, well, because the mother's doing so well, we're receiving glowing reports. We may ask for an extension. We're not certain on that. And it says, but isn't there evidence that she's still living with the boyfriend who also had a CPS case, who's tested positive for cocaine throughout? Actually asks the petitioner, Ms. Watkins there, said, are you still with this person? No, I've moved out. Said, so there's no you don't have kids together. There's no reason to still be with this person. And says, no, that's not the case. Represents that to the court. Then they get together in the January 26th pretrial hearing, still saying glowing reports. The state asked for an extension to give her more time. Right at the time, it was an extension to, or the case was going to be dismissed on March 11th, and said give her more time to work her services, show some more sobriety, etc. Glowing reviews, again, had a clean UA from January. Last year was marijuana only, which was acceptable to the state. And at that time, her attorney not only agreed, she advocated for an extension as well. The trial court didn't grant an extension yet. Said, well, if we're just going to do reunification, then we don't need an extension for that. We're going to move it up to March 4th, which was still within the time frame. But March 11th was the dismissal date. So then everything blew up. Then, unbeknownst to the state, she had given a hair test recently, like a few days ago in January, tested positive for cocaine, was found out that she was still associating with the boyfriend who had been using cocaine, that was there when the aggravated assault happened. It was actually against the mother of his children. And she lied to the court. There's no polite way to put it when she said, I'm not with that person anymore.
If the case has to be dismissed for jurisdictional reasons, that doesn't stop the state from continuing to protect the children if it thinks that that is necessary, correct? I mean, all the things that you're saying could be part of future interventions, et cetera?
That's correct, and we would have to do that, but we're trying to get the state out of their lives. We're trying to get these grandparents in to adopt, so we don't have to do any more unnecessary.
Well, if there's no jurisdiction, I don't know what else can really be done besides say that the state may have to pursue that goal in a procedurally proper way.
Well, the good news is there is jurisdiction.
All right, well, that might be worth talking a little bit about.
Well, first of all, when the extension was granted, the extension was granted February 23rd, 2024. Now we can't have the trial on March 4th like planned, because now it's going to be a contested hearing. If it's just going to be family reunification, it will be a very brief hearing, but now both sides say they need a half a day. Petitioner's attorney is not in the courtroom. She has to be consulted by the phone.
Yeah, but then March 11th comes.
It does, but prior to that,
My question is what I asked your friend on the other side, and that is that by 201.009, that the record may be preserved by any means approved by the associate judge. Why doesn't that just end this?
It does. That's exactly it. An extension was given on the record. Everybody in the courtroom knew about it, and nobody in the courtroom objected. The last that they had heard from defendant's attorney, from petitioner's attorney, was that she had agreed to it, which pushed it all the way up to the date. And then when we get to this pretrial hearing, now we have to have an extension. She did not. The petitioner's attorney did not object. She gave dates. They looked and said, when can we have this before the dismissal deadline of March 11th? They looked at the days before March 11th, had half days stacked up against that in the 1 week that they have a court reporter.
Well, you can make plans on the assumption that it will in fact be extended. So, I mean, one possibility is that the statute about associate judges supplants 101.026. But what if 101.026 is the more specific statute that describes what happens in this kind of proceeding, and that does not give the authority to just say, well, we'll do it however an associate judge feels like doing it?
Well, in that case, then if there was not a court reporter present to commemorate that, then it's incumbent on the person complaining to get that on the record, to complain there's no court reporter.
Did the judge not ask for an order to be prepared by the department?
She did, and unfortunately, there was a misunderstanding on the part of Ms. McGee, and she's beat herself up over this for about a year and a half. Her understanding of the way it was usually done is there's going to be an entry hearing, so she was waiting to hear on the entry hearing. And unfortunately, that didn't happen, so the date came and passed.
And I don't know that she should beat herself up for it. We're humans, and I don't know that anyone needs to cast any aspersions on either side, kind of like Justice Buzzy was saying in the last case. But it didn't happen. And the statute seems to be really focused on the legislature's presumption that it will occur, that a case goes past this time, and when that happens, we're okay with dismissal.
That's true, but the entry of the order is ministerial. The extension was effective when the judge said in court, I am granting an extension on this. And I have to disagree with the contention that there was no present intention. When the court says, I'm going to have to grant an extension, prepare an order, that means I'm granting the extension. So that took place on the record. Everybody's in agreement. And if you accepted the petitioner's view on this, then it would be a really weird outcome, because there's no requirement in the statute that it just says granted. It doesn't say rendered, that the grant has to be in any particular format. So under GXH, if there's written evidence of a timely hearing, and there's no contemporaneous court record, then the court presumes findings, and jurisdiction is not lost, as long as there is evidence that the extension happened prior to that date. If there's a timely hearing with a contemporaneous court's record and an extension's granted, but there aren't findings, it's error, but it's not reversible, because those are jurisdictional. So if you accept petitioner's position, then even if there's a hearing and it's recorded, and that recording is later transcribed, and it is very clear that an extension was given, then the petitioner can remain silent and can fail to object to that extension, and not only fail to object to that extension, give dates of availability, say, I can do it any day that week in April except Monday, which is exactly what the court said that she said. And then
let me ask you about something, changing topic, something you said earlier, that at one point during the case, the mother tested positive for just marijuana, and that was, I think you said, acceptable to the state. And that's, I suppose, understandable these days. It's legal in lots of places. We just had a big debate in the legislature about how apparently
and it was a hair follicle
test.
Available. I'm sorry, I didn't mean to
interrupt.
Yeah,
so my question is, do you have any sense of, maybe in your county, that's okay with the folks that look at these cases? Are there other counties where it's not? We see marijuana use consistently leveled as a reason in, appellate opinions and briefing for why parents should be losing their children. But maybe your department doesn't look at it that way, or?
I definitely don't think, because we have seen parents where that is a factor. I won't say that that's something that is never considered. In this case, it was a hair follicle test, and it wasn't certain how recent it was. It could have been from a slip-up from several months before. Now, if it is consistent throughout, and the person is, and the child tested positive for high levels of marijuana, and there are other problems, and there are other failures to on the part of that person, then I would say, yeah.
Meth is one thing. I wonder whether there's sort of inconsistent, there's a lot of eye of the beholder judgment calls being made about the acceptability of marijuana use at all phases of these cases all over the state, and there doesn't seem to be a whole lot of consistency in that.
I think the best way to put it is that they don't expect perfection, that if there is progress towards that goal, and especially if you are expecting that person to not test positive at a later date on perhaps a urine test that is more recent, then that's, as long as there's progress being made, a step backwards isn't necessarily going to ruin the entire thing. So I'm not going to say that that is never a factor. I'm just going to say that that was something that, looking at reunification as the ultimate goal, that's how the office wins. If that's the happy ending, that's something that the court is, that the state is, willing to consider.
Is that answer the same, is your answer the same as if the marijuana is found in the child system?
You mean if, for example, if the...
Like by secondhand exposure?
If, for example, if there's a monitored return, and during that monitored return, the child has marijuana in their system again, that's a deal breaker. You did the exact same thing that caused the problem to begin with. I can see that I'm in the red now. If I could just, may I sum up just 30 seconds really briefly, too?
Unless there are further questions, your time has expired.
Okay. Thank you very much.
Any further questions? Thank you, counsel. Mr. Stevens.
Morning, Your Honors. I'll start in right on the extension request issue. It was granted in open court. There were obviously complications with the mother's attorney not being present. There was testimony later about why that was. It wasn't an emergency dental procedure. She had a scheduled surgery, and there may have been unforeseen complications from that. But as I look at that situation, what strikes me is she did tell the trial judge later that she went back, looked at the docket, looked at the dates, what had happened when the trial date that she agreed to was set for, and so she clearly knew by February 27th what the status was, what had happened. She certainly could have at that point requested a transcript of that hearing, and so to me that goes to the open announcement of the judge that she was granting an extension at that time.
Counsel, when I read through the transcript that's quoted at great length in the red brief, it doesn't seem like it was a masterpiece. There's a lot of unintelligible and people going out in the hall and talking about things and unidentified speakers. Apparently maybe trial counsel for the mother was, on laughing gas or whatever the dentist did. Wouldn't the states have filing the proposed order for the extension that they were directed to file have kind of clued her in before the deadline passed that, there's an extension coming up and now it's time to think clearly about this and make my objection now or not?
In the ordinary course, that is certainly the state's goal when asked to produce an order. I think you still have to look when you're talking about a jurisdictional matter of was an extension granted. The ordinary course and best case scenario isn't always present, and I think open court granting of the extension, I don't believe, I guess back to my point of what should have counsel done after the hearing where she realized that she wasn't maybe fully present. I think at that point, she did go back and she admitted to the judge, yes, I knew February 27th that the new trial had been scheduled, and I think even today, petitioner's counsel has admitted that there was a conscious decision to wait past that dismissal date before raising anything. And what in the brief, from what I understand, they're relying on is in the DFPS case, there was a suggestion that there was no need to bring to the court's attention the fact that an extension had not been granted. And I think what's critical to distinguish that case is that there was no discussion of any kind of extension in that case. It wasn't a question of was the extension granted in the proper manner, which I would suggest should not be considered jurisdictional.
So, well, that's the big question. I'm not sure that all the other stuff makes any jurisdictional difference at all. There may be ethical issues or whatever with somebody not doing something that might seem unfair. It was for your benefit, you were sick. I get all of that. But if there was no jurisdiction, it doesn't matter really whether she consciously waited for it, was watching the clock, or if she also just didn't realize it. It is what it is, if it's jurisdictional. So the question still, I think, just goes back to whether or not it was actually extended in a lawful way, not what the motivations of the parties were, or whether somebody was doing something in an improper way. Those are just two different inquiries as far as I can see.
Well, I would suggest one way of looking at it, Your Honor, would be essentially an issue of error preservation. So I agree that the court said in JS, whether or not an extension is granted is jurisdictional. But if in this case, we're really talking about the manner in which the extension was granted. So I would say at that point you would go to an error preservation analysis and say, at what point does the party need to object to the manner in which that there was clearly an attempt at the very least, and we think it was sufficient to grant the extension, but at what point does the party who wants to challenge that have a duty not to lie in wait and hope that it works out,
If a parent whose rights was terminated says in open court, I'm going to appeal this, and then the date for the notice of appeal passes, would the state be watching and calling the day before, like, your notice of appeal, aren't you going to appeal? You need to file that notice of appeal. Is that what would happen?
Well, I think it's a very different circumstance here, Your Honor. The point being, in DFPS, yes, there was some indication in this court's opinion that the parent does not have an obligation to come in and say, hey, you never granted an extension. But where the court says, I have to grant an extension, then challenging the manner in which that was granted, was that sufficient, I don't think rises to the level of jurisdiction. It should be something that they can object to and say, well, it's not clear to us that you actually entered this extension.
I guess that then raises the question of, in this particular kind of case, I almost wonder if the opposite might be true. Because the very reason that we're even in this situation is that the legislature said, look, parental termination, that is such a big deal that we're willing to tolerate some cases being dismissed that are entirely legitimate and desirable. That's what the purpose of the statute is. We're just going to say, if you miss this deadline, if you blow past it, case is dismissed without respect to how good the case was, how important it was, any of that kind of stuff. And so if that is just one feature of the parental termination jurisprudence, which is that is always an absolute last resort, we're going to assume that to terminate parental rights, the government is going to sort of have this as priority A, the klaxons are ringing, that's how serious this is, then why wouldn't we expect the sharpest of corners for things like extending the deadline when the legislature's told us that in this context and almost no other, really, the case is dismissed?
Well, I think we have to look to the language of the statute. It's dismissed unless the court grants an extension. And how much are we going to loop in that jurisdictional element to the manner in which an extension was granted? And I think there is a point at which you can go too far, and you have to weigh against the concerns that this court has expressed about classifying.
Would this logic apply in other civil litigation when it comes to a court doing something, a court granting, rendering, entering, et cetera, and we would just say, well, we know what the court meant. Like, we don't need to be worried too much about the way in which it happened.
Well, I will say that I think this is different than a final judgment. It uses different language in terms of granting an extension. So I don't think it's unreasonable to say that it does trigger some duty if there is an objection about the way in which it was done to bring that to the court, to be able to cure it. That's what the error preservation rules are for.
Why would they bring that up if the case is going to be dismissed because you didn't get the order you needed, and you're saying it's their job to point that out to the court? I mean, that's a very strange. That seems to reverse the error preservation burden.
Well, it depends. I mean, in DFPS, the court agreed with that logic in terms of there was no mention of extension at all. And so the court said, you don't have to go out of your way to get that fixed. But if there's something, it's not entirely clear in this case, that's why we're here, does it rise to a jurisdictional matter if it's granted in open court, was recorded, as Justice Lerman points out, in accordance with 201.009 of the Family Code. I think you take a a big risk as a parent to say, well, we're going to rely on something sort of analogous in DFPS and just wait and see and hope. And I don't think that that should be rewarded here. I agree that with DFPS in terms of there's no duty to run in and blow up your entire case. But if they truly had questions, well, was this extension granted? I mean, the court clearly was granting it at the hearing, at the February 23rd hearing. And if there was any question about that, I do think.
I didn't see section 201.009 cited in the red brief. What is OSG's position on the specific versus general canon and everything, whether, I guess subsection C says the record may be preserved by any means approved by the associate judge. Why would that control over the requirement of a written order or a court reporter present?
Well, I would say that the definition of render that's relied on in the brief for petitioners, that term, the render, is not directly correlated with the granting of an extension either. So it's not clear, I guess, that would be the more specific provision of this case. I mean, it seems very specific to say if you're in this courtroom with this associate judge, she can decide what is preserving the record.
And so if the associate judge says, go out in the hallway, that won't even be recorded on whatever gramophone this was being recorded on. And who knows whether mother's trial counsel pushed back and said, hey, that's after the deadline, but I do have this availability. Anyway, I'm going to pass out again from the pain in my mouth. Why would we allow approval of hallway phone conversations that aren't even being recorded, much less transcribed?
Your Honor, I see my time's up. No answer. Well, the statute 201.009 does have other provisions about, if there's a party can provide their own court reporter if they have a problem with the way it's being recorded. I mean, it's not the only, it's not a decree that they can't try to preserve the record some other way if they feel that's appropriate.
Does the state, go ahead, Justice Zimmerman.
No, you go ahead.
Does the state have a position on whether marijuana use is per se relevant to either the endangerment finding or the best interest finding? Not in this case, but just generally.
I'm not aware of per se interest in a decision that's been made about how these things will be treated across the state.
Do you think maybe parents ought to know throughout the state whether marijuana use puts them at risk of losing their children?
Well, I think it always can. I mean, it's certainly related to provisions in the statute about endangering, and so whether there are some localities where the environment, where the judge is operating, maybe it may affect the judge's decision. I mean, parents should know it is always a risk, and I think the state's position is that is something that's relevant to the statute and should be considered. I mean, certainly things do go case by case, and they proceed in different ways. The department and the local, DAs have some authority to try to reunify in ways that they think are appropriate before you get to the full termination stage. So that there is some percolating, I guess you would say, Your Honor, on that issue in the state that may be appropriate.
There's been some talk about some post-submission briefing on 201.09, so could you both please do that?
Yes, Your Honor.
Thank you.
Any further questions? Thank you, counsel. Mr. Bedford, I believe you have 5 minutes.
Thank you. Just briefly, regard to the marijuana use and the drug test results, I think it is notable, and I think it's important that petitioner's levels did trend down throughout the course of the case to not quite zero. She did have some negative UAs, but they were close to zero towards the end. And the children's, they tested positive once, and that was at the inception of the case, and that was at the cutoff level. That was 0.01.
Were they tested later?
I believe they were tested prior to placement with the grandparents, or they have been tested. I can't remember if it's during the pendency of this case or if it's been subsequent to the appeal. But they have subsequently been tested. Now, I can see that they haven't been living with their mom; they've been living with grandparents, but they have not tested further positive. And I think that the maternal grandparents do supervise visitation with the mother. And there's also mention of a positive cocaine, a positive hair follicle that was positive for cocaine. I think it should be noted that petitioner, she did submit to a hair follicle that was, I believe, 2 weeks later, that was negative for all substances. Now, admittedly, that was at her convenience and at her choosing and time, but I still think it is, it is notable at the very least. And there was also discussion of the extension being made in open court. I feel like I should also note that in my review of the case law, that open court language, that predates the enactment of 101.026, and so my argument would be that 101.026, it kind of defines what open court would mean subsequent to 1995 when it was enacted. And so I just want to make that point. And in terms of the second issue of this case regarding the mandatory findings, I don't think that's been addressed at all. And so the question there is whether or not the trial court made those findings, one or both of them, and if not, did petitioner timely object? And I think if you look at the 223 pretrial hearing, there was no discussion whatsoever of the child or the child's circumstances. And so I think it is readily apparent from that record that the child's best interests were not considered and were not part of that decision. Same with extraordinary circumstances. The only thing mentioned were court logistics with a congested docket, with attorney schedules, and respondent believes those are extraordinary, but I contend that those are some of the most ordinary problems that trial courts deal with on a daily basis, and that to label those as extraordinary kind of renders the term meaningless. And so I don't believe either finding was made.
You don't think it's extraordinary for counsel for the parent to suddenly, without warning, have a medical emergency right before the termination date? That seems kind of extraordinary.
Could you repeat that, Your Honor?
Well, there's a medical emergency caused by counsel for the parent, right? And so that seems like an extraordinary.
Well, that was the reason why she was not at the pretrial. That was not. I don't think that was related to the reason for granting the extension.
Well, I mean, they had calendar time. There was a limited amount of additional calendar time. There is another docket, but they wouldn't have needed to. Docket congestion would not be relevant, but for the inability to proceed, right?
Well, I don't think that was due to petitioner's counsel, though. I think that was just due to congested court dockets.
Needing the half a day.
Half a day. And also, should we know, the trial court did not look at trying to have another judge hear it to try to move cases. At least there's nothing on the record indicating that they looked at trying to, let's move this case because we have another month left or another 2 months left on this one and set this one instead. And so there's nothing on the record indicating that was considered. And I do think the legislators' efforts in this area, really indicate their firm belief that these cases need to be resolved quickly and timely, and also to limit these extensions. And when I read that record, what I see is to the extent there's an extension, it's an agreed extension, and it's not extended for the benefit of the child, for the child's best interest, or not because of extraordinary circumstances, but simply just to accommodate schedules of the court, schedules of the attorneys, and schedules of a witness. And I don't think that is what the legislature intended with that particular provision. And so assuming those findings were not made, or at least one or both of them, next question is, was petitioner's objection timely? And I think that's an unsettled question. That's a question that this court poised in footnote 16 of its In Re JS opinion. See, my time is up.
Are there any further questions? Thank you, Mr. Bedford. Thank you to all counsel. That concludes the argument set for today, and the marshal will adjourn the court.
All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas now stands adjourned.